Welcome to the Shaftesbury Society, the John Locke Foundation's weekly event focusing on issues of importance in the public policy and political arenas. And we're going to have a very interesting discussion for you again this week, dealing with another case that's moving through the North Carolina courts, but that also has an implication for policy debates that'll be taking place in the General Assembly during the course of this year, during the short session that will be coming up. North Carolina policymakers are in the middle of a high-profile debate about the future of state health care policy. Medicaid expansion has been attracting most of the headlines, but if lawmakers are going to make a serious move to boost access to health care, they're also going to have to look at repealing or at least taking some consideration of changes to the state's Certificate of Need law. Now, as that policy debate moves forward, a lawsuit challenging North Carolina's CON restrictions, or CON restrictions, sits in the North Carolina Court of Appeals. Oral arguments in that case took place last week, and our discussion today focuses on that case, along with the broader issue of the certificate need rules in North Carolina. Now, joining us today are a distinguished group of panelists. There's one panelist who might be joining us. He's not with us yet. Dr. Jay Singleton of New Bern is the plaintiff in the case that's at the Court of Appeals. He has told us that he would hope to be able to join us, but if he's not, that means he's busy taking care of people's eyes at his office, and so we'll cut him some slack if he's not able to join us during the noon hour. But joining us definitely is Dr. Singleton's attorney in this case, Joshua Wyndham of the Institute for Justice. Also joining us, Matthew Mitchell, who is Senior Research Fellow and Director of the Equal Liberty Initiative at the Mercatus Center at George Mason University, and also my colleague John Guzet, who is Senior Fellow in Legal Studies at the John Locke Foundation. Welcome to all of you. And we're going to start first with Matthew Mitchell of the Mercatus Center, because before we get into the court case that's taking place in the North Carolina Court of Appeals, I want to just talk a little bit about Certificate of Need, where things stand, how North Carolina compares to other states. So, Matt, when you talk to people about CON, Certificate of Need, give us the little elevator speech of what it is and why it's something that should be of interest and concern to us.
Sure thing. Thanks so much for having me. So, Certificate of Need is an unusual type of regulation. It's unusual in a number of ways. First of all, just the aim of it is somewhat quirky. The goal of the regulation is to limit the oversupply of healthcare. And in doing so, what they do is if you want to open or expand a healthcare facility in your state, you have to go before regulators and prove that your community needs the service that you hope to offer. This is odd, of course, because in most cases, the proof is in the pudding. In most other markets, 99% of other markets, the best way to decide whether a community needs a service is for the entrepreneur to assess the likely profitability of the product or service they hope to offer. And they do so guided by the signals of prices, profit, and loss, right? Not so in healthcare. In 35 markets, in 35 states, you have to prove that your community needs the service. Secondly, in this process, they are not going to be inquiring about your qualifications, your safety record, the adequacy of your facility. Typically, they're mainly just second guessing whether the community needs the service. Third, and perhaps most controversially, the regulation puts your competitors in the driver's seat. So when you go before the regulator, in many states, actually your would-be competitors are allowed to sit on the Certificate of Need board evaluating your application to compete with them. Even in states where they do not sit on the board, or if your particular competitor doesn't happen to have a seat on the board at the time, then they are invited to come before the board and oppose your application. So it's often called a competitor's veto because it really puts your competitors in the driver's seat in terms of determining whether or not they would like to have competition. Now, we'll get into the data here in a minute, but the other thing I'd like to emphasize about it that makes it an interesting regulation to study is that it was once required by the federal government, or at least encouraged by the federal government. They withheld federal funds from any state that didn't enact one of these regulations. That happened in 1974. The federal government instituted this requirement. By 1987, it was pretty clear the evidence had already started to emerge that the regulation wasn't working. And so a bipartisan Congress and president repealed the mandate. Since that time, about 15 states have repealed their certificate of need laws altogether. Several more have done away with almost all aspects of the certificate of need process. So now we're living in a situation where 4 in 10 Americans actually live in a state with no certificate of need law. And so we can compare outcomes in those states to outcomes in states like North Carolina that retain these laws. And so the final reason why this is sort of an unusual regulation is that it's extraordinarily well studied. There are about 100 peer-reviewed studies of certificate of need laws assessing everything from cost, quality, and access, and in between. So we know quite a bit about them, and we don't have to speculate on what their effect is.
And in looking at all of that data, it seems to point in the same direction, that certificate of need doesn't have the benefits that its supporters tout that it has?
That is absolutely correct. So not only does it not have the benefits that the supporters tout, it actually seems to undermine each of the goals that they lay out. And it's also quite consistent with economic theory. So it's not like this law or this regulation behaves in an unusual way that we wouldn't expect. It behaves exactly as a supply restriction would predict. So there are 3 principal arguments on behalf of certificate of need laws, and each one, as you probably know, in legislative debates, each one can have subpoints and sub-arguments, and we can get into some of those. But the main arguments are that we need certificate of need to increase access to care. Almost everybody, left, right, and middle, believes that access to healthcare is important. Number 2, we need certificate of need to restrain healthcare costs. Back in 1974, when Congress passed the National Health Planning and Resources Development Act, they said they did so with goals that would sound very familiar to us today. They wanted to bend the healthcare curve. So they were very interested in restraining costs. And then 3, even though the con laws don't specifically address quality, the hope is that they will somehow increase quality. As it turns out, there is extraordinarily little support for any of these claims. The most overwhelming evidence is that con laws do indeed limit access to care. And again, this is quite consistent with economic theory. A supply restriction is going to tend to restrict the supply of care. And so we find that in states with these laws, the typical patient has access to about 30% fewer hospitals, about 14% fewer ambulatory surgery centers, 30% fewer rural hospitals, and 13% fewer rural ambulatory surgery centers. They have fewer dialysis clinics, hospice care facilities, fewer hospitals offering certain procedures like cancer treatment, and certain types of heart care. Patients have to drive longer distances in these states to obtain care, and they're more likely to leave their states in search of care. There's also a greater racial disparity in the provision of care in con states relative to non-con states. And interestingly enough, this large disparity in the provision of care actually goes away when con laws are repealed. So it's very obvious that con laws do restrict access to care. Does that restriction somehow buy better care or lower costs? No, it doesn't. Con laws are also associated with higher spending, both per service and per patient. There's exactly 0 studies that document con laws reduce spending, which is their #1 goal. And then finally, they do seem to undermine the quality of care. And this too is consistent with economic theory. We know that quality tends to be enhanced by competition. And it turns out when you protect hospitals from competition, they don't offer as high a quality of care. And this has been documented in a number of different ways. So for example, there's higher rates of mortality following heart attack, heart failure, and pneumonia in certificate of need states relative to non-con states. There's higher readmission rates for heart failure and heart attack. There are more post-surgery complications. There's higher all-cause mortality in these states. There seems to be actually more incidents of patients rating their hospitals lower in con states relative to non-con states. And nursing home patients even are more likely to be restrained in certificate of need states than in non-con states. So I'm only offering just a short summary of this. We can get into more details later, but it's really extraordinarily well studied, and the regulation works exactly as economic theory predicts, and exactly the opposite of what its boosters claim.
One more question for you before we switch to North Carolina's current court issue on that, and that is North Carolina tends to stack up against other states as being one of the most covered by certificate of need restrictions. Is that correct?
Yeah, that's true. So the state features a very high number of services and procedures that are regulated under con. So, the typical con state, I think, has something like 14 regulated services and procedures. North Carolina has 27. That is second only to Hawaii, which has 28. So in North Carolina, if you want to open a burn care unit, if you want to open a psychiatric care facility or a drug and substance abuse facility, all those instances, you have to go before a regulator and prove your community needs a service. By the way, I mentioned those because it just sort of shows how out of hand the regulation has gotten. Remember, the goal was to somehow, there was a concern that doctors, particularly in the third-party payer environment, might overprescribe. They might have, expensive, fancy equipment, and therefore feel that they need to pay off that equipment, and so they would ask patients to use it or to get certain services even when they don't need it. It's really hard to imagine any physician ordering burn care when somebody doesn't need burn care. It's hard to imagine a physician ordering neonatal intensive care or drug or substance abuse or psychiatric service care when it's not needed. In fact, I think most people believe that in 2022, a lot of these services are underprovided and we need to be encouraging them. So it's kind of, it just shows essentially that the regulation has turned into a powerful tool to protect competitors from competition, not patients or payers from downsides of care.
With that background in mind, thank you to Matthew Mitchell of the Mercatus Center. Now let's switch gears a little bit to a case that's moving through the North Carolina court system that actually deals with this state's certificate of need regulations. We had hoped to hear from Dr. Jay Singleton, eye surgeon in the New Bern area, to tell us his story. It seems as if he is busy actually providing health care to patients, which is a good thing. But the next best thing in terms of telling his story is the attorney who's been working with him and can tell the story very well. Joshua Wyndham with the Institute for Justice has been working with Dr. Singleton to challenge the restrictions of certificate of need on what he's trying to do with his center in the New Bern area. So Josh, tell us a little bit about your client, Dr. Jay Singleton, what he's doing and why he is taking this certificate of need restriction to court.
Sure. Before I do that, can you guys hear me all right? I had to make a switch to my location at the last second.
I can hear you just fine.
Okay, that's great. All right. So my client, Dr. Singleton, is an ophthalmologist. And part of what he does as an ophthalmologist is that he does eye surgery. He works in New Bern, North Carolina, which is in what is called the Craven-Jones-Pamlico planning area or service area, which is a nice Soviet-style way of talking about the way that the certificate of need law breaks up healthcare planning in North Carolina. And he opened his center in 2004, a full service vision center. And over time, he equipped it with the facilities and staff and tools necessary to do surgeries in his office. So he actually has an operating room at his facility ready to go. He's had it ready to go for a number of years now. And it meets all the requirements necessary to get a facility license in North Carolina. So this is kind of a microcosm of what Matthew was talking about. It meets all the relevant health and safety requirements. He's a physician. He's figured out what he needs to meet those requirements so he can safely provide surgeries for his patients. And there's nothing more he needs except one piece of paper, a certificate of need from the state that says this service is needed. Now, the problem for Dr. Singleton is that there hasn't been a new certificate of need available in his area for well over a decade. And the state projects operating room need at least 2 years in advance. So the 2023 State Medical Facilities Plan, at least it's projected right now, says no new need through at least 2025. So we filed this case in 2020. There wasn't a need available. There wasn't a need available this past year. There isn't a need available right now, and there won't be one available through at least 2025. We're talking about a period of at least 15, 20 years where the state has just categorically declared, we don't need an operating room in this area, except if you're an entity called Carolina East, the hospital 2 miles down the road from Dr. Singleton. It has a con to use operating rooms and to run them and to offer surgeries there. So Dr. Singleton, as a surgeon, can go over to Carolina East and perform surgeries for his patients at over triple the cost he himself could charge, but he can't provide them 2 miles down the road at his own facility for a third of the price. It doesn't make any health or safety sense. And setting that aside, and obviously the economic issues with it that Matthew covered, there's the additional problem that in North Carolina, there are constitutional prohibitions on this sort of thing. So it's not just that the law doesn't actually serve the public. Of course, that's a constitutional issue in its own right, but it's that the law creates a monopoly. North Carolina's constitution has an express prohibition on monopolies and granting special privileges unless the person having the privilege is providing some kind of public service. This is a private healthcare service. So giving this hospital a special privilege to control this particular market isn't a public service. It's just enriching and kind of padding the pockets of Carolina East.
Before I ask the next question, if at some point you need to get up and help whoever was emitting that cry, we will understand and we'll get back to you in a bit. But Josh, from what I understand, in the case of Dr. Singleton, there are some procedures in which he can do part of it in his own office, but then has to do the rest of it at the hospital, and Con won't let him do the entire procedure there in his office for the lower cost, even though it would be very easy to do so?
Yeah, it's a little bit odd, but the way the law works in practice is that Dr. Singleton can actually provide some of the pre-op care in his facility. So, he can do some of the pre-op care necessary, get the patients, kind of outfitted in their what do you call them, scrubs, and everything, kind of like do all the stuff you would need to do right up until the point where you're actually making incisions. But then at that point, he and the patient have to go down the road to Carolina East, where he can then start making cuts. And this is not an economical system. It's inefficient. It's cost inefficient, and there's not really this is the same procedure being done in exactly the same way. There's not a health or safety difference between these two things. It's just that the state has said, we don't really need you in the market.
Okay, so the case is in the North Carolina Court of Appeals. You had oral arguments last week. For folks who haven't been following it very closely or who aren't up on how legal proceedings work, tell us what is actually being debated right now at the Court of Appeals and what that court will decide.
Yeah, well, just to give a little bit of background, Matthew mentioned this federal law from 1974. And so North Carolina is kind of an interesting, maybe the most interesting state on the certificate of need front, in my view, because in 1973, the North Carolina Supreme Court actually said that the state's prior con law, in a case called Aston Park, violated the state's constitution in multiple ways, including by creating a monopoly in established providers. Well, the following year, Congress passed this National Health Planning and Resources Development Act. And then in 1978, under, I think, a fair amount of pressure, state legislators said, well, we really need that federal money. And so we're going to reenact our state's con law. And, rather than just reenacting the same law, we're going to append a bunch of findings of fact about how the law is really necessary this time to protect the public health and lower costs and increase access and all of that. So that law hadn't been challenged for a long time. And our lawsuit attempts to say, well, the Aston Park decision, stated the correct constitutional principles, applied them the right way. And under that logic, this new con law with kind of a prettier face, should fall for the same reasons. Now, the state filed a motion to dismiss our case in 2020. We ended up getting dismissed for basically failure to state a claim, which is a fancy way of saying your constitutional claims can't prevail here. And so we filed an appeal, and what we argued last week was whether we did in fact fail to state a claim.
So if the judges at the Court of Appeals decide in your favor, you would then be able to go back to the trial court and start over with trying to get to a trial?
That's exactly right. I mean, if we prevail at this stage, we're going to go back down to the trial court. If we don't, there will inevitably be an appeal. This it seems possible this case can't really be resolved at the end of the day until the North Carolina Supreme Court weighs in on it, in part because it's a little bit detailed, but there's a kind of tension in the case law right now between this 1973 decision from the state Supreme Court and a 2010 decision from the Court of Appeals that went the other way. And so there's this tension in the appellate courts right now in North Carolina about which case controls and how are they distinguishable. And so it seems like that's not going to be able to be fully untangled until the North Carolina Supreme Court weighs in once again.
Yeah, you've referenced this already, but it is important to note again that the courts already struck down the first version of North Carolina's con law. Is the certificate of need law this time around that much different, or is it the same type of thing that the courts struck down the first time?
No, I mean, they're substantially the same in practice. If you think about, so what the North Carolina Supreme Court did in 1973 was it said the prior con law, which conditioned the ability of a hospital to get a facility license on obtaining a certificate of need, which divided the state up into, basically planning areas, made need determinations based on each planning area, and then declared there wasn't a need for the particular hospital in that case in its area. That law worked the exact same way as this law. This law divides the state up into planning areas, declares no new need for new services, and people whose products or services or facilities aren't declared needed, they can enter the market. So they operate in the same way. There's not a meaningful difference between the two. It's just that, like I said, in 1978, when the legislators decided, well, we really want to enact this law again, even though it's already been declared unconstitutional, they listed a bunch of reasons why it was really important that they pass the law. And so that's apparently the difference between this one and the last one.
Well, certainly very interesting legal issues. And now we bring in my colleague, John Gouzet, who is the Senior Fellow in Legal Studies at the John Locke Foundation. And John, the John Locke Foundation has been focusing on this issue for quite a while. We've had healthcare analysts talking about con and why it's something that should be removed. From your vantage point, looking at this as a legal scholar, you've been focusing on why con does not seem to square up well with constitutional protections. Tell us some about that.
Well, that's right. We've, of course, as you said, opposed this for as long as I've been involved at the John Locke Foundation on economic and public health grounds. But what's interested me about it is the constitutional, and at Josh's request, we actually filed an amicus brief in this case supporting Dr. Singleton. And the thing we focused on is some interesting history about the anti-monopoly clause that's an important part of our Constitution. What we found is that this clause goes back to the founding of North Carolina. It was in our original Constitution in 1776. It was carried over into our second Constitution that was ratified after the Civil War, and is in our current Constitution too. And what we point out in our amicus brief is that this is really a fundamental right that has been important to North Carolinians since there's been a state of North Carolina. In fact, it even goes back to colonial times. It's interesting to note that the Court of Queen's Bench in the UK found that monopolies are against common law all the way back in the early 17th century, when North Carolina was hardly more than a gleam in Walter Raleigh's eye. And subsequently, the Parliament passed a bill, an anti-monopoly bill in England, that forbade monopolies. Ironically, though, or unfortunately, that bill was specific in that it only forbid monopolies within the realm. It didn't apply to the colonies. And an important part of the tension between the American colonists, including the colonists in North Carolina, and the Crown was that the Crown continued to grant monopolies on various kinds of trade in the colonies. One example of that is on the tea trade. You may have heard of the Boston Tea Party. That was in part an anti-monopoly protest. And that event would have been forefront in the minds of the members of our state legislature when they enacted our first Constitution and included an anti-monopoly clause in the Declaration of Rights that's appended to that Constitution. So this is a fundamental right by any measure, one that's firmly rooted in our history. And maybe if we get time, Josh will explain why that's important in terms of how the court looks at this particular law.
While we're with you, John, you had a chance to sit in the audience and hear the presentation that was taking place during the oral arguments at the North Carolina Court of Appeals. As someone watching with an interest, but from the outside, what was your sense of how those proceedings went?
Well, let me say first, Josh did an excellent job. And he was hindered somewhat because he was peppered with questions almost from the time he opened his mouth. I'm sure he found that a little frustrating, but he handled it with aplomb. And he made the important points, which is that this law is unconstitutional. It's been declared unconstitutional. And I wouldn't say the judges were as well informed about this as I would have hoped they were, but they listened respectfully, and we'll just have to see how they decide.
Before we get back to a broader perspective of con across the country, I do want to loop back to Josh and say to him, you had a chance to hear the questions. Were they the type of questions that you were expecting from the judges? And did you get any sense of how those questions might lead to an eventual decision?
Well, I mean, it's hard to read tea leaves, as lawyers often say. I think that the best way to describe the decision is that I would put it at a toss-up in terms of odds. I mean, it seems like on the one hand, there were some judges, at least one judge who I thought, really felt like this con process is very complex. The state legislators worked really hard on it. You have a bunch of legislators who work every year on this very, multiple 100-page plan. And so, like, why shouldn't a doctor have to go through this very rigorous process before he can finally, file a lawsuit? And that's the concept is exhaustion, right? You've got to go through the complex administrative process before you can challenge the laws underlying the process. That's kind of a jurisdictional issue that goes to court subject matter jurisdiction to hear a case. Now, there was another judge who seemed to really get the case. He described the law as anti-competitive. He kind of peppered my opponent on the anti-competitive nature of the law. He emphasized that, look, I mean, it seemed like the state was kind of defending the general rationality of the law, whereas the kind of challenge we've brought is called an as-applied challenge, which really focuses on the facts of the particular client before the court. And the reason that matters is that, as I mentioned before, the law is kind of clothed in this series of findings of fact about how important it is that dates back to 1978. Well, we're here in 2022 talking about the rationality of the law as applied to my client in this particular area, right? So whether the law is constitutional as applied to him today doesn't and shouldn't turn on, what some legislators thought about the law over 40 years ago, right? So one of the judges really seemed to kind of get that angle. And the other judge I would just describe as, with respect to him, a little confused about the way the law worked. He asked a line of questions that I confess I still today don't quite know what he was getting at. I think that perhaps he was just confused about the way the law actually worked. And so, my perspective on how to deal with that was to kind of emphasize in the simplest terms that I could, the law works this way for the other two judges. Hopefully that judge's clerks can kind of help him explain, before he writes his opinion or casts his vote. But I would describe it as a toss-up with one maybe against, one maybe for us, and then one we'll have to see how he lands.
Well, we'll definitely be watching, of course, as this case proceeds, and we expect a decision at some point in the months ahead from the North Carolina Court of Appeals, a 3-judge panel that heard oral arguments in this case last week. We also want to remind you, if you are paying attention to our proceedings on our Facebook page, facebook.com/John Locke Foundation, you could submit questions for our panelists. And we do have one that I'd like to get to since we've been talking about the legal issues with Josh and John, and either one of you or both can weigh in on this. But Roger asks at our Facebook page, this doesn't fall under Sherman Act of 1890, the Clayton Act of 1914, and the Federal Trade Commission Act of 1914. Either of you wish to weigh in on whether those pieces of federal legislation have any impact on con? Josh, I see you up there.
All right, Josh. Go ahead, Josh.
Yeah. I mean, I'll confess, I'm not an antitrust lawyer. I bring constitutional cases for a living. I sue the government for a living. One thing I found kind of interesting is that, to the extent this came up, I had a judge actually ask me why I didn't bring an antitrust claim. And part of the reason that we don't bring antitrust claims at IJ, and that I didn't feel was appropriate here, is that antitrust claims are really suits against market participants. You can bring them against government entities. That's a relatively recent development in the law. But, more broadly, they're against private entities. And so, what we wanted to do with this case was to try to reestablish a principle that dates back to, as John was talking about, not only the founding of North Carolina, but even before that, which is that the main problem with monopolies isn't when a private entity gets really big or something. The main problem with monopolies is when the government gives a favored market player a special right to operate in a market and then bans everybody else from that market, right? And kind of gives you the corner on the street. That's the real problem with monopolies in our view. And that's the constitutional problem with monopolies. And so our case is really focused on this original meaning of the anti-monopoly clause.
Right. Could I just add to that? I think a lot of people don't understand that the meaning of the word monopoly has changed or expanded over the years. And this is something else we touched on in our brief. At the time of the founding, when the anti-monopoly clause was added to our Constitution, monopolies meant exclusive privileges granted by the sovereign. That's what it meant. And it was only subsequently applied by sort of analogy in the late 19th century to these big trusts that started to occur. And that's what the antitrust laws are about. But that's not what we're dealing with here. This is a different kind of a monopoly. It's interesting that the state's brief, they're trying to defend the con law on the basis of a number of cases that deal with the kind of monopolies Josh was just talking about, big private organizations that succeed in cornering the market. But that's not what we're dealing with here. These are monopolies granted by the state. It's a different kind of monopoly, and it's one that is specifically forbidden by our state constitution.
Yeah, I mean, you can think of it.
Go ahead, Josh.
I'm sorry. Well, I was just going to say, you can think of the difference in kind of simplest terms as like there's a difference between economic and like sovereign or political power, right? Economic power isn't really the kind of power government should be concerned with, in my view, because it just involves, I mean, at the end of the day, what's an economic power other than just the ability of the company to produce a valuable product that lots of people like, right? That's economic power. It's like your persuasiveness or your value. But political power or sovereign power is the ability to use force to say that somebody can or can't participate in the market at all, right? Can or can't run their business or can't offer their product on the market. And one of those is just much more dangerous to individual liberty than the other. And that's what really our anti-monopoly clause is worried about, is sovereign power or political power.
That is Josh Wyndham of the Institute for Justice. Is defending Dr. Jay Singleton in this case. Dr. Jay Singleton out of New Bern, who is challenging the way that the Certificate of Need law has been applied against him and the service that he is trying to provide to his clients and customers and consumers. You also heard from John Guzet, Senior Fellow in Legal Studies at the John Locke Foundation, and also on our panel, and I now want to bring him back in, Matthew Mitchell, Senior Research Fellow and Director of the Equal Liberty Initiative at the Mercatus Center at George Mason University. And Matthew, you've heard some now about the North Carolina case. Is this the type of thing that we're seeing in other states across the country that still have various challenges that arise as people run up against this law that a lot of people just don't even know about?
Yeah, absolutely. So to think about the economics of it, and I think this kind of dovetails with the discussion of monopoly, is couple things in mind. So first of all, there is the legal question of, if you and I agree to divide a market, we're going to be sued by the Federal Trade Commission for restraint of trade. That's an illegal cartel. It's considered a per se violation of the Sherman Act. However, if we do it under the color of the law and we have it organized by the state, thanks to a doctrine known as Parker immunity, we are immune from that. So the way I try to describe this to students is there's a scene in Nixon v. Frost that's from real life when President Nixon was interviewed by the journalist, I think his name is Robert. No, it's not Robert Frost, that's a poet.
David Frost?
There we go, thank you. Nixon says, well, if the president does it, it's not illegal. And that's basically the idea of state organized monopolies. If the state organizes a monopoly, it's not illegal. But there's another extraordinary advantage if you are a private actor here, is not only can you avoid, violating, getting in trouble with antitrust if you ask for a state organized cartel or monopoly, but it's far more effective. The history of private cartels is a history of cartels coming together and then breaking apart. And the reason is it basically has to do with game theory, but it's once you and I form some sort of scheme to divide a market, to keep prices above what the market would bear, or to limit competition, I have an extraordinarily strong incentive to cheat on our scheme, right? And to undercut you. And so most private cartels fall apart, but that's not true for public cartels. So George Stiegler, the famous Nobel laureate, in an important piece in 1971 describes this very well. He says, the state has one basic resource which in pure principle is not shared with even the mightiest of its citizens, and that is the power to coerce. So the state can use its coercive power to keep a cartel agreement going that otherwise would fall apart because of the strong incentives in a prisoner's dilemma. So anyway, I just wanted to give that little background. But yes, this stuff is being challenged all across the country. The problem is that the benefits of con, and there are benefits because it offers some short-term monopoly profits, they accrue to a highly concentrated and well-organized group, hospital associations. The costs of con, and as I said, that's very well documented, they accrue to politically weak organizations and groups, to patients who don't even know that these laws exist or what their effect is, and to would-be competitors who are just getting started and typically don't have the political power to fight them. One other aspect I'd mention here is that the groups that tend to be on the losing end of this are often, frankly, just overwhelmed. So because need is subjective, there is no objective way to evaluate need. Need is something, it's in the eye of the beholder. These groups, if their desires aren't shared by the authorities, then they're overlooked. So for example, we just had a recent case involving IJ, actually, where some people wanted to start a home health business in Kentucky that catered to the specific cultural and linguistic needs of Nepalese immigrants. Again, need is subjective. These immigrants have specific needs, but the regulators didn't seem to take those into account. Similarly, there's another case in New York where an all-female Hasidic group of women wanted to start a ambulance service that catered to the specific needs of their community. Again, they felt that if a woman is in trouble and needs to call an ambulance, she might be in a compromising position in the shower or whatever. She doesn't want a group of men showing up and taking her to the hospital. For her, her subjective need is to have somebody who's sensitive to her specific needs come pick her up and take her to the hospital. Well, the regulators don't care about that. For them, it's just an objective fact. Is there enough ambulances or not? We don't have to worry about what the subjective preferences of the consumers are.
Can I add to that briefly?
Go ahead.
I was just going to say that, not only is need subjective in the sense you're talking about, Matthew, and really hard to figure out and prove, but it's also the case that con laws like to treat it as objective. So like North Carolina system, for example, just to bring things back to North Carolina, has this very complex formula that pencil pushing bureaucrats in Raleigh have all kind of come up with and said, we can use this formula to kind of punch a bunch of numbers in, and then it's going to spit out need 2 years in advance, right? So it's not even the case that we're predicting need today, or we're saying we can use data from the past to predict need in the past. No, we're trying to predict the future 2 years from now about what a market will need, which is crazy in two ways. One, just think of Steve Jobs, right? He's an innovator. You don't know you need an iPhone until you see an iPhone, right? So in that sense, how on earth are you predicting need with a formula? But in the second place, think of COVID, right? When you have a health emergency, how can you predict that need 2 years in advance? Nobody would have thought we would have had, a global pandemic that would have upended healthcare markets. And then you see what happened in New York, right? Where there was a massive shortage of hospital beds in New York. The state had to relax its certificate of need law after the fact so that people could build these kind of makeshift hospital setups on the streets because there weren't enough hospital facilities in New York because of the con law. So there's just not a way to adequately, predict need in a scientific sense, and certainly not if you're the government.
And not to belabor the point, but if I could add one point to that, those formulas, everything you just said is absolutely spot on. But think about the way the formula works. So the formula says if existing providers aren't using a certain percentage of their hospital beds, then a new provider won't be allowed to come in because, oh, the current beds are underutilized. So let's think about this from the perspective and the incentive of the existing provider. I know that a competitor's hospital beds won't be approved if I make sure that I have a whole lot of beds that go unused. So this encourages me to acquire a bunch of resources and not use them, which is the exact opposite of what certificate of need was supposed to do, which was not encourage you're supposed to discourage the acquisition of unnecessary equipment. So, it really has a bunch of perverse incentives too.
A lot of this sounds like it flies in the face of economic history and what we learned in economics class. I heard concentrated benefits and dispersed costs a little while ago and thought back to Econ 101. Josh, I want to get back to you on the issue of Dr. Singleton, because we know he has his suit. He is in the North Carolina Court of Appeals now, awaiting a decision from the 3-judge panel there. Had he taken a different route and decided, okay, I'm going to try to pursue getting a certificate of need, just remind us briefly what he would do starting day one today if he wanted to get a certificate of need to do the things that he wants to do in that surgery center, and about how long would this process take if he had any level of success?
Well, I think one way to start framing this is by saying that the state accuses Dr. Singleton of sidestepping the con process, which is just a fiction, because there's not a need determination right now, right? And so the question is, like, how would he create a need determination? It's not like in many states, he could just go before some agency and submit a really cool, detailed application with a lot of consultants and prove that his services are needed. No, he's got to wait until the state says there is a need, and then he can submit his application and fight with other people for the con. So right now, no need determination. What he could do is he could submit a petition to try to change the need determination by adding a new OR in 2025, right? So suppose that he is successful. Suppose he submits a petition, he convinces these bureaucrats, yep, we really need a new OR. Mine's the one we need. In 2025, a new con opens up in the Craven Jones Pamlico area. Well, the hospital down the street, Carolina East, has already told him verbally that if he files an application, it will oppose his application. So what's going to happen? Well, he's going to have to submit a $5,000 non-refundable fee application. He's going to have to work through a months and months and months long, hearing process. Carolina East will submit its own application for a con, or it will oppose his, which will trigger a process called a contested case hearing, which basically just resembles litigation. So that's going to go on for several more years. It ultimately can make its way up to the Court of Appeals and the Supreme Court. And these cases do often. I mean, there's a ton of money involved in them. So you have to hire attorneys, and you have to do discovery, and you go before a judge, and you have to hire consultants. And it just is a process that takes, and we've talked to con consultants, it takes hundreds of thousands of dollars and several years to actually go through this process and get a final decision on a con. And if people honestly think that Dr. Singleton, as a solo practitioner, or as a small practitioner rather, is going to prevail against Carolina East, a hospital with $1 billion annual budget that's had a corner on the market for decades, that just sounds like a fantasy to any rational person, because it is.
And all of this would be to get permission to do something that, from what I understand, he could already do. He has the equipment, he has the facility. All of these things are things he could do if he had the permission. Is that right?
And he is doing. Josh, tell him about the fact that he's already performing these surgeries.
Yeah, I mean, that's one of the silliest things about this, is that there's a bizarre little exemption in the con law in the Ambulatory Surgery Facility Licensure Act that basically says you can do incidental procedures in your facility. So he does about 15% of his surgeries right now in his operating room. His operating room is accredited by the relevant entity that you would have to have your facility accredited by to get the facility license, right? He just can't get the full license that would allow him to treat this as a formal surgery facility for all of his patients on a regular basis. And all of this, the law doesn't say it, but all of this is really bound up with insurance and kind of Medicare and Medicaid and what they're willing to reimburse for. But yeah, I mean, it's kind of silly, right? Because a few of his patients every year are actually able to get surgeries in his facility, and they benefit. I mean, they've told him, you know, you saved me tons of money. I may not have been able to get care at Carolina East, or I would have had to delay care or go without care entirely. And so thank you for, you know, charging me. I think Dr. Singleton, for cataract surgery, for example, can charge $1,800 for his facility fee and surgery fee. Well, Carolina East charges $6,000 for its facility fee alone, right? So we're just talking about a massive, massive upcharge to go 2 miles down the road for the exact same procedure.
Very complicated, and certainly the Court of Appeals is going to be weighing in on this in the months ahead with this case involving Dr. Singleton. I want to return now to my colleague John Guzet, and of course, one of the issues is what happens with Dr. Singleton and his case. Taking the broader look at North Carolina and its policies, what do you hope comes out of this case other than a win for Dr. Singleton? What do you hope that it spells in terms of North Carolina policy moving forward?
Well, as Josh mentioned, this is an as-applied challenge. So even if Dr. Singleton prevails, it's not the same as striking down the con law. That would take a facial challenge, and maybe there'll be an opportunity to do that at some point. That would be nice. But even without that, I think this is going to be a very big step forward as far as North Carolina's con law is concerned, for a couple of reasons. One, the state actually pointed out during the hearing last week, is that if Dr. Singleton can win on these facts, a lot of other healthcare providers will be able to win on similar facts in North Carolina. That in itself will probably start a wave of litigation that will free a lot of people from this unfair restriction. But in addition to that, we've seen this over and over again. When there's litigation involving these kinds of constitutional violations, that's what it takes many times to get the General Assembly's attention. When they see that a law is under attack and likely to lose in the end, that gets the General Assembly to finally come together and make some changes and sometimes even repeal a law, which is what I hope will happen in this case.
Our time is winding down during this hour, so I want to give each of the other panelists a chance to talk about some of the closing thoughts that they would like people to take from this. So let's go to Matthew Mitchell of the Mercatus Center. Matthew, people who've been listening to us throughout know that you've been focusing on the national con picture, where things stand. Just give us a sense of recent con victories and what you hope to see in the next few years in terms of dealing with these restrictions moving forward.
Sure. So it might be helpful to give a little context on the states that don't have con, why they don't have them. Most of them repealed it immediately following the elimination of the federal mandate. But since then, the more recent repealers, Pennsylvania did it about a decade and a half ago. New Hampshire did a full repeal that took effect, I believe, in 2017. Florida did a repeal of everything but the con for nursing homes and a few others that took effect this year. And Montana did the same, even more sweeping than Florida. They eliminated every con but that for nursing homes. For whatever reason, retaining the nursing home con for states that reform, it tends to be a pretty popular way to do it. I would emphasize again, this is not data driven. States that retain the con for nursing homes spend more on Medicaid, and their patients, as I mentioned, are more likely to be physically restrained and taken care of in lower nursing staff ratios, and other metrics of care seem to be worse in those states. So there's not an evidence-based reason for doing this. But the nursing home lobby appears to be extremely effective. So con repealing states like Montana, Indiana, Ohio, they often retain the con for nursing homes. Right now, con reform is moving forward in South Carolina. It's passed the Senate, and is headed to the House and the governor, and it's expected actually to get a better reception there than it did in the Senate, and it was passed resoundingly actually by the Senate. So That is a full repeal except for nursing homes as well. And then as was mentioned in the case of New York, actually about 24 states eased or relaxed or suspended their con laws to help deal with the pandemic. Unfortunately, in a lot of cases, the way they did this, providers had to either surrender whatever equipment was acquired during the relaxation or go and get a new con after the emergency went away. So in a lot of cases, you actually saw providers not even wanting to acquire the equipment because they didn't want to have to surrender it or expand. Also, or surrender it or apply for a con. The other thing is, this is all dependent. If you need to be able to plan. That's ironic, because the con law advocates think that they have a superior planning strategy here. You need to be able to plan for equipment acquisition. So if suddenly, yeah, great, you can get a bed, but you were denied a con to build a new hospital wing last year and you have no place to put the bed, it doesn't really help. So unfortunately, I think a lot of those relaxations during the pandemic were sort of too little too late. So now the attention is turning to states like South Carolina to see what happens.
I'm going to turn to Josh for the final word in just a moment. But first, we do have another question on Facebook from Tom, who says, barring the legal outcome of this or pursuant cases on con, what is the legislative landscape for its repeal? And I'll give a brief answer to that, since our panelists today are not particularly following the legislative process as closely as in North Carolina, the legal process, and from Matthew's perspective, sort of the national picture of con. But I do know that there has been quite a bit of interest, at least in the state Senate, in dealing with, if not full-scale repeal of con, at least some significant scale backs. And that is one of the issues that I believe is going to be discussed by this committee that has been set up as part of the state budget approved last November, in which a committee from both the House and the Senate is looking at both the idea of Medicaid expansion, but also increased healthcare access. And one of the increased healthcare access pieces certainly has to be the certificate of need law. So we may see some action on certificate of need at some point during this legislative session coming up. So that is a brief partial answer to Tom's question from the John Locke Foundation's Facebook page. Now, for the final word before we sign off, I'm going to turn back to Joshua Wyndham of the Institute for Justice, who is the attorney working with Dr. Singleton in his case at the North Carolina Court of Appeals. We know you'd like Dr. Singleton to win at this stage and then eventually get to a trial and win there. Beyond just that simple goal, what is your ultimate hope of what happens both with this case and this case potentially setting a precedent for the future?
Well, I mean, yeah, the short-term goal is to get the reversal, and if we don't, I'm sure we'll appeal. The long-term goal in this case is ultimately to have North Carolina courts and hopefully North Carolina appellate courts and ideally even the state Supreme Court recognize that the principles that animated the decision in 1973 are not relics of the past. They're principles that date back to the founding of this state. They're embedded in the Constitution of North Carolina. They're embedded in the deep policy and culture of this state. And those principles really aren't that hard to explain. They're that, like, in this state, we favor free competition. We favor open markets where anyone can kind of earn their living by honest effort and work and, rise or fall according to their merits. That's a basic American principle, but it's a principle embedded in the express language of North Carolina's Constitution. You have language not only that prohibits monopolies, right, but you have language in Article 1, Section 1 that guarantees to every citizen, the right to the fruits of their labor. You don't find that language in any other state constitution. You have decisions throughout the 20th century in North Carolina that over and over again extol the virtue and value of open markets and free competition and economic enterprise and kind of the dignity that comes with doing that, right? And so what we have in this case is kind of a microcosm of all those issues, because you have a guy, Dr. Singleton, who I think John Locke, Carolina Journal actually did a really great profile on him that kind of went back and told his story as an individual and kind of how he brought himself up out of kind of a modest upbringing to become this, really kind of self-made man. And what he's trying to do with his career is to is to help people with all that he's earned, to help people with his qualifications, to help people with his facility that he's built. And he's really an innovator, right? He's trying to make life better for his patients, as any good doctor would try to do. And what's standing between him and providing a valuable service and helping people in North Carolina? It's the use of government power that's basically telling him no, like you're not welcome here. That's just so antithetical to the culture and law and constitution of this state that it really can't stand.
It's a good way to end this discussion. And of course, we'll be following at johnlocke.org and carolinajournal.com the proceedings in this case. That was Joshua Wyndham with the Institute for Justice, who is the attorney working with Dr. Jay Singleton to challenge the Certificate of Need law as applied to him in New Bern. You also heard from Matthew Mitchell, Senior Research Fellow and Director of the Equal Liberty Initiative at the Mercatus Center at George Mason University, and from my colleague John Guzet, who's Senior Fellow in Legal Studies at the John Locke Foundation. We thank all of you for joining us, and we'd like to thank you for watching today, either on the John Locke Foundation's page or on our YouTube channel or on the Facebook page. And thank you for the questions as well. If you like these programs from the John Locke Foundation and would like to support them, please log on to johnlocke.org and look for that donate button. Until next week, we thank you for joining us once again, and we'll see you again 1 week from today. Thank